Welcome back, everyone, to another deep dive. Today, we're tackling a case with some pretty big consequences for, well, everyone, really healthcare and how it's funded. The case is Azar v. Allina Health Services. Buckle up.
Sounds intense.
It is. In a nutshell, the Supreme Court sided with the hospitals on this one. They agreed with a lower court's ruling. And at the center of all this is a question about procedure. Did the agency that oversees Medicare, the Centers for Medicare and Medicaid Services, did they follow the right steps, the rules in place, when they made a decision about how much extra money certain hospitals get?
Right. These are the hospitals that treat a lot of low-income patients and rely on those extra funds to keep things running.
Exactly. Those extra payments are partly based on something called the Medicare fraction. It's a calculation, really. It looks at how many patients a hospital serves who are on traditional Medicare, Part A, compared to the total number of patients they see.
And the way that fraction is calculated well, it can make a huge difference in how much money we're talking about. It can shift billions of dollars across the hospital system.
Billions. Wow. Okay, so let's break this down a bit. Before we get into the specifics of the case, can you remind us about the whole Medicare fraction thing? Why is it so important to hospitals in the first place?
Sure. So you've got Medicare Part A, which is the original way Medicare works. The government directly pays hospitals for the care they give to people covered by Medicare. It's pretty straightforward.
Makes sense.
But Congress realized that some hospitals, especially those in lower income areas, end up treating a much higher proportion of patients on Medicare, who often have more complex medical needs.
Right. And those hospitals might struggle financially if they're not getting enough to cover the costs.
Yeah, exactly. So to make things fair, Congress set up a system to give these hospitals extra payments. And the Medicare fraction is a big part of figuring out how much each hospital should get.
Okay, that makes sense. So then Medicare Part C comes along. How did that shake things up?
Medicare Part C, also called Medicare Advantage, was created in 1997. It's basically a different way to get your Medicare benefits. Instead of going through the traditional Part A system, people can choose to enroll in private insurance plans. And the government, instead of paying the hospitals directly, pays a premium to these private plans.
So this is like having a middleman between the government and the hospitals.
Yeah, that's a good way to put it. Now, the big question that came up is, how should those Part C enrollees, the people in those private plans, be factored into the Medicare fraction calculation? Should they be counted as people who are entitled to benefits under Part A, even though they're getting their coverage through a private insurer?
I see where this is going. The hospitals probably had some strong feelings about that.
They did. The hospitals argued that people on Medicare Part C tend to be wealthier and healthier, on average, than those in traditional Part A.
Okay, so if you include those Part C patients when you're calculating the Medicare fraction, the fraction would look smaller.
Right. And a smaller fraction makes it seem like the hospital is serving a smaller proportion of traditional Medicare patients who are more likely to be lower income.
So the hospital would get less money.
Exactly. They argued that counting Part C patients would mean they'd get significantly less in those extra payments, potentially billions less across the whole hospital system.
Wow. So how did the agency handle this initially? Did they count Part C patients or not?
Well, at first they didn't. But then, back in 2004, they changed their minds and issued a formal rule saying they would start counting Part C patients. It was a big change, but at least they did allow for a public comment period before putting that rule into effect.
So people had a chance to weigh in, but that 2004 rule didn't stick around, right?
It didn't. The hospitals weren't happy about it, so they took the agency to court, arguing that the change wasn't justified. The courts agreed with the hospitals and threw out the 2004 rule.
Okay, so back to square one. What happened next?
Fast forward to 2013. The agency makes another attempt, issuing a new rule, again stating that they'd count Part C patients in the Medicare fraction. But this time, they made it clear this new rule would only apply going forward.
Perspective, as they say.
Exactly. But here's the thing. This case we're talking about, Azar v. Allina, it's about fiscal year 2012.
Right. So neither the old 2004 rule, which had been thrown out, nor the new 2013 rule, which wasn't in effect yet, applied to 2012. What did the agency do then?
Well, instead of going through the whole formal rulemaking process again, they just kind of posted the Medicare fractions for each hospital on their website. And you guessed it. Those calculations included Part C patients.
So that's what triggered this whole lawsuit. The hospitals were upset that the agency didn't go through the normal notice and comment period before making that change for 2012.
Right. They weren't necessarily saying that counting Part C patients was inherently wrong. They just argued that the agency didn't follow the right procedure in making that change for 2012.
So what was the legal basis for their argument? What part of the law did they say the agency violated?
They pointed to a section of the Medicare Act, Section 1395 HSU, which says that the agency has to give public notice and allow 60 days for people to comment before they make any changes that affect payments to hospitals. That includes any rule, requirement, or other statement of policy that establishes or changes a substantive legal standard governing the payment for services. The hospitals claim that posting those 2012 fractions with Part C patients included was basically a change in how they were being paid, and that the agency should follow that notice and comment process.
Makes sense. So what did the government say in their defense? They acknowledged they skipped the notice and comment part, so what was their justification?
Their argument was that what they did in 2014, posting those 2012 fractions, wasn't really a new substantive legal standard. It was just an interpretive rule. They claimed they were just explaining how they understood existing law. And under the Administrative Procedure Act, or the APA as it's called, those kinds of interpretive rules and general policy statements, they're usually exempt from needing public notice and comment.
So the government was basically saying, look, we're not changing the rules, we're just clarifying what the rules already mean.
Exactly. But that's where the disagreement lies, and that's where the Supreme Court steps in. They had to decide whether what the agency did was substantive and therefore required notice and comment under the Medicare Act, or if it was interpretive and exempt under the APA.
A pretty crucial distinction, I'd say.
It was. The Supreme Court ultimately sided with the hospitals. They said the government was wrong in their interpretation and that the Medicare Act actually has its own set of rules about when notice and comment are needed, and those rules aren't exactly the same as the APA's.
Okay, so what were the key reasons the court gave for ruling against the government on this?
Well, they pointed out that the Medicare Act specifically says that statements of policy can in fact establish or change a substantive legal standard. And that's a big difference from the APA. Under the APA, policy statements are generally seen as just interpretations. So the court basically said that the agency couldn't just claim their policy of counting Part C patients, which is how they came up with those 2012 fractions, was just an interpretation and therefore didn't need public input.
Right, because according to the Medicare Act itself, even a policy statement can be a big deal, a substantive change that needs to go through the proper process.
Exactly. And they also looked at another section of the Medicare Act, Section 1395 HE1. That section deals with when the agency can make retroactive changes to their rules and policies, and it specifically mentions interpretive rules and statements of policy. The court basically said, look, if substantive meant the same thing in the Medicare Act as it does in the APA, then this whole section wouldn't make much sense.
Because under the APA, interpretive rules and policy statements aren't considered substantive anyway.
Right. So why would Congress put limits on when the agency can make retroactive substantive changes to things that aren't even considered substantive in the first place?
That's a really good point.
Yeah.
It implies that Congress, when they wrote the Medicare Act, had something different in mind when they used the word substantive.
Yeah, they were clearly operating under a different definition than the APA. And the court went on to highlight that while the Medicare Act does reference one specific exemption from the APA, the good cause exception, it doesn't mention the APA's exemption for interpretive rules and policy statements.
So they picked and chose which parts of the APA to include.
Exactly. And the court saw that as a pretty clear sign that Congress meant to create a different process for Medicare stuff, especially when it came to how hospitals get paid. If they'd wanted the APA exemptions to apply across the board, they would just said so directly. The court also noted that the phrase substantive legal standard isn't really used anywhere else in federal law, which suggests it has a specific meaning just within the context of the Medicare Act.
So they really looked at the language and the context.
They did. And the government tried to bring in legislative history to support their view, what Congress intended, but the court wasn't convinced. They said the history wasn't clear enough to outweigh the plain language of the law.
So the text of the law itself was the deciding factor.
Pretty much. The government also argued that requiring notice and comment for every little policy interpretation would just be too much work, too burdensome. But the court shut that down, saying it's Congress's job, not theirs, to figure out those policy considerations. Their job was to interpret the law as it was written.
So a clear victory for the hospitals based on the specific wording of the Medicare Act. But were there any justices who disagreed with this line of reasoning?
There was one Justice Breyer. He wrote a dissenting opinion, arguing that he believed Congress intended the Medicare Act's notice and comment rules to be basically the same as the APA's.
So only applying to major rules, not just interpretations or policy statements.
Right. He worried that if the majority's view was adopted, it would create a huge bureaucratic mess. He said the agency would have to go through this long, drawn-out process for every little clarification they issued, even minor ones, and that it would slow everything down.
So he was concerned about the practical impact on the agency's workload.
Exactly. He thought it would be inefficient and not what Congress had intended. But the majority opinion emphasized the importance of sticking to the specific language of the Medicare Act, even if it meant more work for the agency. They felt the potential burden on the agency didn't outweigh the clear intention of Congress, as expressed in the law itself.
And now it's time for our favorite segment, the 10th chair. So, put on your justice robes for a moment. If you were on the Supreme Court hearing all of these arguments, where would you have come down on this case?
Well, as the 10th Justice, I think I would have to side with the majority on this one. Justice Breyer's concerns about the administrative burden are certainly valid, but at the end of the day, the language of the Medicare Act seems pretty intentional. Congress specifically called out statements of policy as potentially being substantive. They could have easily just copied the APA's language wholesale, but they didn't. They clearly wanted a different process for Medicare.
So you'd err on the side of following the specific statute, even if it creates some headaches for the agency?
I think so, especially when it comes to something as important as how hospitals are funded. It's really Congress's job to fix any problems with the law if it's too burdensome. The court's job is to interpret what's already there.
This has been a really insightful look at Azar v. Allina Health Services. It just goes to show how even the most technical-sounding legal questions can have a huge impact on people's lives. Any final thoughts for our listeners?
I think this case is a great reminder that it's really important to understand the specific laws that govern different areas. The general principles of administrative law are important, but sometimes Congress decides to do things differently. So it's crucial to pay attention to the specifics of the statutes themselves to really understand how things work.
Thanks for joining us on this deep dive. We'll be back soon with another fascinating case from the Supreme Court.
See you then.